It is important to look at the issue for Priya's case, whether Priya has a claim for a discrimination against SPC for refusing to accommodate her medical condition and allowing her to only work days 9 a.m. until 5 p.m. and not operate or be involved with machinery. The legal principle under the case is under the Equality Act 2010. Section 20 of the EA 2010 prohibits discrimination against employees on the grounds of disability. Specifically, it states that it is unlawful for an employer to treat a disabled person less favorably than they would treat a non-disabled person in similar circumstances because of the employee's disability. Additionally, Section 21 of the EA 2010 states that it is unlawful for an employer to fail to make reasonable adjustments for a disabled employee where a provision, criterion, or practice of the employer places the employee at a substantial disadvantage in comparison with persons who are not disabled. This includes adjustments to working hours and duties. The employer has a duty to take such steps as it is reasonable to have to take in the circumstance to avoid the disadvantage, especially for Priya's medical condition of epilepsy, which causes seizures, would be considered as a disability under the EA 2010. SPC's refusal to accommodate to her by allowing her to only work days and not operate or be involved with machinery may put her at a substantial disadvantage compared to a non-disabled employees. By refusing to make this accommodation, SPC may be in violation for their duty to make reasonable adjustments under the Section 21 of the EA 2010. It should be noted that in the UK, the burden of proof is on the employer to show that they have taken all reasonable steps to avoid the discrimination. This means that the employer must prove that the adjustment that is being requested is not reasonable or it cannot be made without incurring disproportionate burden. If Priya can provide evidence that SPC's actions were discriminatory and that they have failed to make reasonable adjustments for her, she may have a valid claim under the EA 2010. In analyzing the case, it is important to consider relevant case law. For example, in the case of Archibald versus Fife Council in 2004, the court held that an employer's failure to make a reasonable adjustment for an employee with a disability which would have allowed them to return to work amounted to discrimination. In analysis for Priya's case, Priya's medical condition of epilepsy which causes seizures is considered as a disability under the Equality Act of 2010. According to the case law, employers have a duty to make reasonable adjustment for employees with disabilities to ensure that they are not at a substantial disadvantage compared to a non-disabled employees. This includes adjusting working hours and duties. Priya's doctor has advised Priya that she could only work days 9 a.m. until 5 p.m. and she should not be operate or be involved with machinery. In this case, SPC's refusal to accommodate her by allowing her to only work days and not operate or be involved with machinery may put her in a substantial disadvantage compared to a non-disabled employee. By refusing to make this accommodation, SPC may be in violation of their duty to make reasonable adjustments under the Equality Act of 2010. Based based on the case of Archibald versus Fife Council, can be compared to Priya's situation in terms of the legal principle, legal principle of reasonable adjustments. Like Miss Archibald, Priya has a disability, epilepsy, which affects her ability to work on the council, and the council has a duty to make reasonable adjustments for her to help her overcome any substantial disadvantage she faces as a result of her condition. In Priya's case, her doctor has advised that she should only work days 9 a.m. until 5 p.m. and should not be able to operate or be involved with machineries. SPC's refusal to accommodate her by allowing her to only work days and not operate or be involved with machinery may put her at a substantial disadvantage compared to a non-disabled employee, as it will affect her ability to perform her job as a packer. Another key case to look at is the All Answers versus W in 2021, the case which dealt with the question of when to assess whether a person is considered disabled under the Equality Act 2010. The statutory test in the Act states that an impairment is considered long-term if it has lasted for at least 12 months, is likely to last for at least 12 months, or is likely to last for the rest of the person's life. The court in this case determined that the correct date to assess whether a person is disabled at this time of the alleged discriminatory treatment, not at the time of the hearing. The case was sent back to the tribunal to determine if the claimant's impairment were likely to last for at least 12 months at the time of the alleged discrimination. To relate with Priya's case, her seizures are incurable as her disability is likely to last for the rest of her life. It is likely that the court would find that she is considered disabled under the Equality Act 2010. This would put the burden on SPC to make reasonable adjustments to accommodate to her disability. Therefore, this case works in Priya's favor as it established that the correct date for assessing whether a person is considered disabled under the Equality Act 2010 is at the time of the alleged discriminatory treatment, and that her disability would be considered as a long-term under the Equality Act of 2010. For my conclusion in Priya's case, Priya may have a claim for discrimination against SPC under the Equality Act 2010 for their failure to make reasonable adjustments for her disability. If she is able to prove that SPC's actions put her at a substantial disadvantage compared to a non-disabled employees, the SPC has already failed to make reasonable adjustments to accommodate to her disability. She may be successful in her claim. If Priya were to win her claim, she would be entitled to remedies such as compensation for any loss suffered as a result of the discrimination. This could include compensation for any financial losses, such as lost wages, as well as compensation for any injury to feelings. Additionally, the court may order SPC to take steps to prevent similar discrimination in the future, such as implementing policies and procedures to accommodate employees with disabilities. However, if Priya were to lose her claim, it will mean that the court determined that SPC has met their duty to make reasonable adjustments. SPC would not be required to make any changes to their policies or procedures, and Priya would not be entitled to any remedies. Thank you.